Good morning, everybody, and welcome to today's lunchtime seminar, Securing Truth-Telling, Whistleblower Protection for Investigative Journalists. You're all very welcome this morning. This is the third lunchtime seminar organised in a series of events hosted by Transparency International Ireland and Whistleblowing International Network to raise awareness of the EU Directive on Whistleblowing and the implementation of evolution of whistleblower protections across the EU. These seminars are possible thanks to funding under the Citizens' Equality, Rights and Values, a work of the European Commission under the Strengthening and Fostering Enabling Environment for Whistleblowers in the European Union programme. This is a project that has been going on for over 2 years now and is drawing to an end at the end of next month. We are delighted today to be co-hosting and co-organising this event with La Maison de Lanceurs d'Alert, the House of Whistleblowers, which is a leading organisation protecting whistleblowers in France. As I mentioned, this webinar is being recorded and will be made available on the EU Whistleblowing Monitor at a later date. I'll start with some brief introductions before we get on to the substance. My name is Ida Nowers, and I lead the EU Whistleblowing Monitor for the Whistleblowing International Network, who I will refer to as WIN, and Transparency International Ireland. This is a newly revamped online tool which tracks how the directive is being implemented across member states. I myself spent a number of years advising whistleblowers on whistleblowing dilemmas in the workplace and as well organisations on effective whistleblowing systems. And before this role, I did work at WIN myself as Law and Advocacy Manager for a number of years. Joining me today, we have Anna Myers. Anna is a lawyer and the founding executive director of the Whistleblowing International Network. WIN, as I will refer to it, is a global network of civil society organisations that work to protect and defend public interest whistleblowing. Anna spent 20 years in this field, advising whistleblowers and organisations, as well as policymakers at the international and national level. She worked at the Group of States Against Corruption and at the Government Accountability Project in Washington, D.C. She was Deputy Director of Public Concern at Work, now called Protect, for 9 years. Anna is originally from Canada and holds a law degree from Dalhousie University in Nova Scotia and a history degree from the University of Montreal. Thank you, Anna, for joining us. We're also delighted to be joined by Charlotte Clavreul, who is Chief Executive Director of Fonds pour une presse libre, pardon my pronunciation, in English known as the Fund for Free Press. She is a law graduate with a degree in human rights and humanitarian law from the Sorbonne. Charlotte has worked at the United Nations and for NGOs advocating for migrants' rights. She served as advisor on international affairs and fundamental rights at the French Human Rights Defender and coordinated the General Secretariat of the Association of Human Rights Defenders in the Mediterranean Basin since 2020. She leads the Fonds pour une presse libre, which was created in 2019. So thank you very much, Charlotte, for joining us also. And then last but not least, we have Moira Oblites, who is Communications Manager at the Maison de Lanceurs d'Alert. Moira is a political science graduate and has worked at Tournon La Page, again, please pardon my pronunciation, which is a network of African pro-democracy activists campaigning against third terms. Moira has become increasingly interested in the protection of journalists since 2024 and has been working at MLA, as I will refer to it, which, as I mentioned, is an organisation dedicated to protecting whistleblowers and advancing their rights in France. I also just very quickly want to mention Edward Haswell, who is with WIN, who has been supporting on the EU Whistleblowing Monitor, and it's thanks to him today that we're able to get online and will be on hand for any technical issues. So a big thank you to Ed for getting us all here today. I'll just run through the agenda. We have 4 items, and as I mentioned, a full 20 minutes Q&A at the end of the presentations. Each speaker will speak for about 10 to 15 minutes. Firstly, Anna will speak about the EU Whistleblowing Directive, give some practical insights on what the provisions that are relevant to journalists are. I myself will then give a presentation of the new EU Whistleblowing Monitor as it has been revamped. Oh, just going to mute somebody this there. And as a tool potentially for investigative journalists. Charlotte will then give a presentation on the risks that journalists may face when working with whistleblowers and strategic litigation against public participation, or SLAP suits as they have become to be known. And then Moira will kindly present a new guide for journalists, again on working with whistleblowers. I'll then take over to run through some questions. So without any further ado, with a slightly clunky introduction there from me, I'm going to pass the floor directly to Anna to talk us through the EU Whistleblowing Directive. Anna, the floor is yours. Thank you very much.
Thank you so much, Ida. Just making sure everyone can hear me now.
Perfect.
I wanted to, first of all, thank Ida for putting this together and for all of you for coming. There's quite a few slides here with some issues that I'm happy to pick up later as well. I won't speak to every point, but I think we really want to start with making sure that we're grounding this discussion in this important relationship between journalists and whistleblowers. And certainly over the plus 20 years that I worked in the field, I've watched as journalists have taken much more of an active role in both thinking about what their sources, the sources for their stories, what they face, and seeking some advice themselves when they think that their sources are putting themselves at risk. And I think if you want, there's a podcast I did recently with Matthew Caruana Galizia at the foundation, the Daphne Caruana Foundation. And very early on at something that I was at years ago, he joined because he very much felt that the issue of sources, certainly the people that worked with his mother, he understood it, but he hadn't really thought about it as a legal as whistleblowers of having legal protection. And I don't know that we want to talk to you about what those protections are. It's very important that journalists understand the risks that whistleblowers can take in going to journalism, and the fact that whistleblowers can be raising things at different levels at different times and may not become sources. So it's sort of getting a broader sense of where the whistleblower protection field has arrived. So clearly, we know that journalists working with whistleblowers can turn their accounts into absolutely compelling narratives. And those narratives publicly known are much, much easier for those to drive accountability and reform in the sector. And also, journalists often rely on insiders when investigating wrongdoing or issues within what would otherwise be closed institutions. Most of these people are because they're in a working relationship, and because so much of the laws are protecting the running of these institutions, they can run up very quickly against their confidentiality, loyalty, various other workplace rules and requirements on them. And they're not necessarily speaking about their own situation at work. They're talking about issues at work that affect the public interest. So over the years, there's been an ongoing development of this very important piece of the puzzle of accountability, where whistleblowers who speak up, who, if they then are in this vulnerable position by virtue of being at the workplace, need protection, then of course it starts to really explore, the laws start to really explore where they should go, where they have those concerns, and how they should be addressed, and how we should protect those people who have a particular relationship in the workplace, and they may be putting their careers and their livelihoods at stake. So most people start by raising things internally, and many of your journalists will perhaps know of people. Some you'll get tips directly, but it doesn't necessarily mean that they haven't started to raise the issues internally first. And those who in the workplace often do that. And it's often the response rather than that they really start to understand they might have a more serious issue. And by the time they go to journalists, they may have had a long journey. So I think, those of you who are long in the tooth will know this, and you have to sort of unpick what's happened. But that's why a legal framework is trying to cover the protections for those who speak up internally within their organizations or to the organization that's legally responsible, obviously providing protection to regulators, and really in trying to use both innovative tools, evolving best practices in law and in how you deal with sources to really ensure that whistleblowers are protected through the process if they're going to go public. And for many, that's a big jump. So what's been really important is that over the years, that certainly the journalist community has started to become very much more involved in safeguarding whistleblowers and seeing legal protections as helpful to their work and championing strong protections. And that's what happened around the EU directive, where the journalist organizations really joined the trade union organizations, worker rights organizations, and the whistleblower protection organizations in Europe to then argue and try to get an EU whistleblowing directive that would be very helpful. Of course, even then, there's always some things that are not in the process of negotiations that are a bit more vague. And then we see the EU directive being transposed and implemented, and there's challenges there. Next slide, please, Ida. So I think this is important. It was said in the recitals of the EU directive that whistleblowers are, in particular, important sources for investigative journalists, providing effective protection to whistleblowers from retaliation increases legal certainty and thereby encourages whistleblowing also through the media. In this respect, protection of whistleblowers as journalist sources is crucial for safeguarding the watchdog role of investigative journalism in democratic societies. So I think thinking about this as accountability and seeing that role, these are very great words. And then we have to see how these are really applied in practice. And so we can see that the directive is doing a lot of things at the same time. But I think there's some really, really pioneering aspects of this. Next slide, please, Ida, that is helpful to understand. So what has happened, and this is just a big move forward, is that before the directive came into place, only 8 of the EU members had adopted some form of dedicated legislation. Now all 27 members have. It took them a little bit of time, unfortunately, and they face some serious fines for their delays. But it is groundbreaking. It's certainly described that way. But we know that when you have a directive, then you put it into the national laws, and how those national member states have, whether or not they've consulted, whether or not they actually have really thought through all the elements and really seen how it fits into their legal system. We've seen transposition happen in less than ideal ways, but the aim of the directive was to very much harmonize protection across the EU. And so we're moving into this phase now of really seeing not just what's on paper, but how it's being implemented. And in 2024, there's been the first compliance report saying that there's, identifying some serious gaps, and there have been reforms already. And we had, which was very interesting, the Court of Justice of the European Union took action, and 5 countries are fined up to 38, altogether about 38 million euros for their delays. The last 2 countries to transpose the directive was Germany and Estonia, and they did that in 2024, I think. So they're quite late because there was 2 years for them to adopt all the member states to transpose it from the end of 2019. So they were quite late. But what was interesting was how the fact that the Commission certainly then, we hope it will continue to play a very active role in enforcement. So there is a bigger evaluation of implementation now underway, and it would be good to look at that and to see what happens, especially on some of the matters that would affect or that journalists would be interested in following. Next slide, please. So I think some of the key elements, really what we're seeing across the board is the fact that we have reporting channels and feedback. So I would say that national systems now are requiring organizations to have these channels, and they're talking about for reporting across both public and private sectors. And it includes channels to authorities, and then the law does protect for public disclosures. What it also includes in these channels is requirements for feedback and follow-up is an institutional requirement. And this is new in the field of whistleblower protection, because until now, there haven't really been duties on organizations to do things well, to set things up well, to set things up at all, and to have some minimum standards for that. And I think that's where we come back to what we're talking about with whistleblowing. We're not just talking about the protection of whistleblowers, we're talking about the free flow of information for the responsible exercise of institutional authority throughout our societies. And therefore, we want to ensure that people don't have to stay in one place. If they have concerns, they can go to the next accountability mechanism. So that's where regulators now have to do some of these things in terms of having the feedback and the confidentiality, and can be sued if they do not meet those minimum standards. So there is also a stronger protection and clear protection measures around confidentiality, keeping the identity and the identifying information that could disclose the identity if people saw it confidential. And if there's any absolute reason, they have to give advance warning to an individual about why and how that would happen. It also provides immunities, and we've seen, that there is if you take, let's say, for example, the LuxLeaks case, which was one of the cases prior to the EU directive being implemented, and for those of you in the journalist space at that point and in Europe may have been well aware of Antoine Deltour, who blew the whistle. He basically went to Edouard Perrin and gave him information about what was almost industrial scale what were they, agreements that PwC was helping companies make with the Luxembourg tax authorities to basically put their profits through at a much lower tax rate through Luxembourg, where they may not have really done any of their work. And it became a huge scandal. But Antoine Deltour faced basically being charged with all sorts of things, including breach of banking secrecy, stealing data, as well as going outside, going to all of those things. And he was really, he was facing huge fines and potential jail time. And the issue, I think, really took off because there was so much work being done on tax justice in Europe. But we can really see in the scenario that how he was treated and the public outcry and the fact that a journalist was also charged and they were going through the courts really did start to change the narrative. It was seen as something that this one person was taking the fall for disclosing information that needed to be addressed. And in the end, the European authorities did say that it was legal what was happening. It wasn't necessarily clear at the start, or people weren't sure. And again, this is one of the cases that really pushed for an EU directive. The other cases, I think, were also very important, and I'll just mention briefly, were the actual murders of two investigative journalists, Daphne Caruana-Galizia and Jan Kuciak, along with his partner, which were terrible atrocities really in Europe. And it shocked people and it shocked the EU, certainly, and it shocked all of the European citizens that this had happened in Europe. And interestingly enough, one of the responses was to really push for a whistleblowing directive when there had been no appetite before, or had been very slowly pressured. So those two cases really has pushed this forward. So there are penalties put into the EU directive for failure to meet the minimum standards on identity. And the immunities, that I was going to mention are against, when I mentioned the LuxLeaks case and sort of he was the issues like stealing data. If you are raising a concern and following the directive, then you are immune for cases where that are taken for those who have reported according to the directive. So you can't be sort of protected in one place and then being sued in another for stealing the information or for defamation. It's there, but of course we now know that there is an EU directive on defamation, slap suits, which have been overly abusively used against journalists and their sources, and other people can talk about that in even more detail. But what we're getting is a stronger framework for saying people should be able to speak up when there's an issue that is in the public interest, that it's not just illegal, wider breaches, which is the scope that is broader in the EU directive, a broader range of who's protected. It's workers and third parties and facilitators in the workplace. So we're saying it is important that information reaches the right place to those who can do something about it. And we know that the public also can do things about it when they know, and it's the public's right to know. So we've got an interesting directive, and we've got now laws, and how we review these and how we use them will be very important in developing and evolving these protections in reality at the national level. The next slide, please. So it covers Every sector that's new, again, mentioned that it's beyond the employer-employee relationship. So it's a bit wider, and it does cover those who support whistleblowers. And it's about acts or omissions. So it's beyond things that are illegal or unlawful. It's where they're raising concerns about issues where there's been failure to act or positive acts that are defeat the object and purpose of the rules. That's very legal speak, but what from a point of view of a journalist and those who might not be into the weeds on this, it means that it's about those where that could cause harm or undermine the rules. And that's the EU laws, right? So the EU directive was set up and it covers EU law, but every country was very much encouraged by the Commission to extend it to any breaches to any laws, and that's happened to a wide extent in how it's been implemented. And it does, for the first time, really in the European space, say that you can raise things internally or to a regulator externally, but you can go directly. And obviously, in certain circumstances, and there's some tension there, but they've put some boundaries around going publicly. But if there's a good reason to go publicly, they've put that into the EU directive to say you can go to the media. And so we will. The other point that's quite important about anonymous whistleblowers in the EU directive, it doesn't force companies or regulators to take on anonymous whistleblowing reports or to protect them in the first place. But if they are subsequently identified and are retaliated against, then they have to be protected under the law. And so those are requirements on EU member states. Next slide. So again, minimum standards across the board. Most public and private organizations need to have them. There is this follow-up aspect with entities and competent authorities. So again, if you're thinking about your sources, this is all very important. A lot of stories that come through to the media are about the failures to act on information, and not only the value of the disclosure and the information that was provided. Of course, that's very, very important. If there's harm being caused, if laws are being breached, that disclosure is really important to examine and go through. But also a lot of times where there is accountability in some of these situations is because the organizations themselves have failed to deal with it, failed to respond, failed to act, or the regulators as well. So these are important aspects of what they should be doing, and it helps sometimes for journalists to know that those steps have been taken. The story becomes very, very powerful as well when that has happened well for the whistleblowers. It also said there should be free, comprehensive, and independent advice. The Whistleblowing Network provides a lot of the organizations within the network are advice centers, nonprofits trying to find ways to fund that service. But now it's saying that the national authorities need to provide access to comprehensive and independent advice. And it does prohibit quite a wide range, pretty non-exhaustive list of types of retaliation in the workplace. So it can be things that stop your career from moving forward, that your job responsibilities are diminished. Of course, dismissal is covered, and other forms of detriment, including threats or attempts to retaliate. And I think hindering people from going outside or from raising concerns is an important part of what the directive prohibits. Next slide, please. These things, I think the big thing that may be, and it'd be interesting to talk about this a little bit more, but in the legal sphere, what was ending up happening in a lot of the tribunals or courts when whistleblowers were going forward and saying, I raised this concern and then I suffered retaliation, there was an element of did you do it in good faith? And good faith was being used as a bar, was allowing employers to kind of say, go after the whistleblowers or the employees, former employees or workers on the basis of their motivation, whether they were doing it because they had some other agenda. And what it stopped, it was like a bar to even looking at the case to see what the disclosure was and what had happened. And everything would stop with the motivation. So it's been made very clear in the EU directive that that's not relevant, that what people need is a reasonable belief. And they have to show that based on their circumstances in the truth of what they're saying. The fact that they might have other agendas can't be a bar to looking at the actual disclosures and then how it was responded to by the employer. And they can't contract out. And this is, again, a really important one. They're still having arguments in different parts of the world about gagging clauses, loyalty to clauses, people signing NDAs. If there's a public interest issue, you can't stop someone from going outside, but how well known and how that's implemented is a challenge. Next slide, please. And there's a little bit more about the reasonable belief, and I think that's an important one because we have to sort of distinguish between the reality of being legally protected, showing that you acted with some grounding in the disclosure, that you weren't acting on tiny frivolous things, but at the same time not having to prove that that everything about you is perfect for you to get protection when you're raising something that is an important issue. Next slide. I think it's really important to note, and what we've had of sort of from a legal point of view, a pretty big revolution in legal protection since 2010 in particular. So you can see from 1990 until 2000, there were 4 dedicated whistleblower protection laws, 4 countries that had implemented them. Between 2010 and 2020, there's been 35. I would say the big jump after 2010 was around the anti-corruption agenda, and lots of work being done to say people should be able to speak up. Government employees should be able to speak up. There wasn't a lot around protection, but that was starting to come into force. Once the EU directive came into force, again, there were a few before 2010, but not many. We've had this big jump because we can add at least 18 of the EU member states adding those. And I think this number now is 63 because Senegal has just adopted a whistleblower protection law. Next slide. Again, I think it's really important for journalists to just, and I'm sure this is something that's probably quite clear in many ways when you think about it, but this whistleblowing protection is really about accountability, the information getting to the right place, or, getting to those who have the authority, the power to act. And it seems sensible that most people could raise things within the organization. The organization should have a vested interest in being able to address it. But we all know that not all organizations are doing things well. They can cover things up for a lot of reasons. They can fail to address it, and they can be deliberately involved in serious issues. So there needs to be alternatives that people can go to regulating authorities. Again, if that's not working, then they need to be able to go outside. And this is just a very quick diagram that was included in the explanatory memorandum to the Council of Europe. Recommendation on the protection of whistleblowers that still applies to all the EU member states, and as well as European Court of Human Rights jurisprudence, which also applies. And so we have got 3 sort of in terms of the legal framework in the that affect EU member states, but also Council of Europe member states, the wider European sphere, and with respect to the Council of Europe and the European Court of Human Rights, for instance, in the UK still. It is important that we remember why we want to protect whistleblowers, because it's really important that things are addressed early, stopped, that there is accountability, and ultimately that the public has the right to know about this. Next slide. So public disclosures, which is the key aspect for journalists in the directive, talks about anyone who makes a public disclosure shall qualify under 2 circumstances. Either they've already reported it internally and externally, or directly externally, which they're allowed to do, but there was no response taken within the time frame. So then going outside is quote unquote reasonable and would be protected. The other way that they are protected for going outside is that they have some reasonable grounds to believe that there is imminent danger and manifest danger to public interest. So, when you think about it during COVID, we had a lot of doctors and nurses, et cetera, going directly to the press about the problems they were facing and the lack of particularly the safety equipment. And people weren't stopping to say necessarily that they should raise everything internally. People were doing it pretty directly because there was a manifest danger, and everyone saw it. So we can see that when it's really serious, but sometimes we have to, really explore that situation. So manifest or imminent danger doesn't have to be COVID style, but it does need to be there in some ways, such as there's an emergency situation or risk of irreversible damage. So you don't have to wait and you can go more widely. And in the case of external reporting, so it feels like that's not an option, that's not available. There is no regulator. There's a low risk of the breach being effectively addressed. So other people have gone to that regulator and nothing's happened, or they're pretty clear. People can show that to at least a reasonable ground to believe there would be retaliation if they did go into a regulator. Then in those circumstances, they can also go public. There's certain countries like Sweden who has a constitutional right for people to go public. So that's still protected and shouldn't be removed in any way because of the EU directive. Next slide, please. Some of the early, so in Sweden, in fact, there was some concern with the new whistleblower law weakening press freedom. These are just two headlines. Croatian journalists have slammed anti-leaks bill. There has been some concern about the ways in which these laws have been implemented and how well they are ensuring that journalists' sources can be protected, and that it isn't something that tries to hinder the appropriate use of people going outside and being able to speak up about concerns. It also is important that the European Court of Human Rights does make it clear that, we want access to information for an ongoing public debate about important things. And so we will see some of these issues being addressed as it moves through the cases, move through the courts and through to the European Court of Human Rights. But I think so many of the steps that journalists take to protect sources, to work on the information, there's so many ways that you have to really protect whistleblowers, and this law is more a backup for you rather than something that necessarily is a problem. But we will see how it really works when the reviews of the laws come into force, but there's more of it from the European Commission, but also as we see how it actually works in practice, and we'll all be vigilant because we need to remain vigilant throughout. Next slide. This is just about implementation challenges. Next slide, Ida, and this is where I will end. There are still issues with transnational cases and cross-border cases, and I won't go into detail here. I'm going to move on and let other people speak. But in the case of Jonathan Taylor, which is one that some of you may be aware of, who was a whistleblower in 2013 and 14, he raised concerns about his former employer, SBM Offshore. It was to do with the Petrobras scandal in Brazil. He was a UK lawyer. SBM Offshore is headquartered in Monaco. I mean, there's so many jurisdictions in which what he raised was then investigated. Brazil acted, the US acted. There were quite serious investigations against SBM Offshore, his former employer. And then in the end, he was stopped in 2020 on a short trip to Croatia with his family because of this, the employers still going after him. And what can happen is going after him as they actually face more of the prosecutions. The original disclosure and how it goes on is can cause the employers to go after these people. And when they have this cross-border nature, we really want to know how the EU directive will work better, the regulating authorities, whether they're working together across borders, and how civil society can continue to work with insulating whistleblowers in their work, and journalists really thinking cross-border how you can protect whistleblowers and the information. So I'll leave it there and hand it over to Ida for the next speaker. But I hope that was helpful in an overview sense.
Yes, thank you so much, Anna. Whistle stop tour, as we say, of the whistleblowing directive. It's really a huge piece of legislation, incredibly complex, but I think we covered off the core issues very well. I'll just take 5 minutes now to quickly present the EU Whistleblowing Monitor before the next guest speaker. Hopefully, many of you have seen this website already. I'll pop a link into the chat. Essentially, this is a website or an online tool, as we call it, that by we, I mean the Whistleblowing International Network, created in 2019, just after the adoption of the directive to track how well EU governments were doing or how speedy they were being in transposing. So here we have the previous logo and the previous methodology that we used, which was very simple, just not started, law adopted, and transposed. And the idea behind having a tool as this online is not only that citizens could come on and hold their governments to account for the work they were doing or not doing to transpose the directive into their national legal systems, but also on the idea that nobody wants to be a laggard. And there was a huge amount of interest in this tool at the very beginning. We've been grateful to have over 50 completely voluntary country editors who are those, whether they are lawyers, trade unionists, or indeed investigative journalists, who could see the importance of a robust or progressive transposition of the directive in their jurisdictions. And so we're keen to monitor what was going on the ground, share it, and then we would post it up on this new website. And of course, once all of the member states had adopted laws, it's very difficult for us to say as a civil society network, yes, they have effectively transposed. We realised that there was still very much an appetite to continue that monitoring, that tracking of EU efforts through from transposition into implementation. And so thanks to funding under the SERVE programme and the Safe for Whistleblowers project implemented by TI that I mentioned at the beginning, we've been able to completely revamp the monitor so that we can better track the situation nationally, but also have some of that comparative data as well. So this is the homepage of the new website. It's been live for a few months now, and we've been trying to raise awareness about it through the seminars such as this today. And you can see straight away that we have a clear visual of the latest updates. So in Italy, there have been some new guidelines published by the competent authority and some concerns raised by the civil society organisations looking at this topic. And then as well, very interesting developments in Slovakia, where the government had moved to dismantle the new Whistleblower Protection Office. I won't have time to go into that now, but this is a very interesting sort of flurry of events that happened at the end of last year. So moving swiftly on, similarly to the Whistleblowing International Network, there is a resources library. You can find in here all of the transposition legislations and those new reform laws, which Anna mentioned, have already been adopted in some countries as they realise their laws weren't up to scratch. We also have a blog function and then regular roundup of updates. So all of that information is available online. There's been interest, particularly from the academia side, those looking at the process and of transposition and now the quality of implementation and using this information. And we know policymakers also log on and see. We were contacted when early on in this monitoring project by government ministers saying, well, hold on a minute, we are doing something, we should be put in progress, not started. But of course they weren't necessarily being transparent or raising awareness about what they were doing. And so our answer to them would be, don't tell us, tell the public. You should be publishing that online and engaging in that transparent and inclusive consultation on the national proposals. We have two new interactive features. We have an implementation timeline, so you can see exactly when each country did what, from passing a law to the infringement proceedings that the Commission have taken against member states, and then any findings in the European Court of Justice as well. And then forthcoming would be this qualitative analysis. So we created a methodology across 5 criterions, looking on not just what does the directive require as a minimum standard, but what are the best practice from global experience that we would want to see in these laws. So hopefully, again, we can have members of the public, lawyers, or other advocates coming on and saying, well, these areas are what my country needs to improve on. And then we have developed these country pages. So before, the monitor would have resources and blogs EU-wide, but now all of that information is available for each country. So if you're looking at your respective countries and you notice that there isn't the information or a resource that's missing, in particular, it would be fantastic to have more information on cases, whether that's those inside the courts or indeed being reported in the media, because also a big part of the implementation of proper whistleblower protection isn't just in the law, but it's also that cultural revolution. I don't like that word, but the moving from whistleblowers having that stigma as snitches or grassers into seeing them as sort of everyday heroes reporting information on wrongdoing, not for their own benefit, but for the benefit of us all. Just to very briefly mention the network of European integrity and whistleblowing authorities. This is a fairly new European-wide network. Again, I'll put a link in the chat. Our website is hosted on the monitor now. This is, I think it's around 50 organisations across the member states which are working with whistleblowers in different capacities, whether that's giving them advice and support, actually investigating wrongdoing themselves, or acting as a sort of signposting body. If you're interested in that, there's a number of resources about their competencies and some of the best practice guidance that they've put out available on the monitor as well. Just a final word before we move to our next speaker. We're really pleased to see that the EU Whistleblowing Monitor has also inspired other civil society organisations to set up their own monitors. Indeed, there is now a European anti-slap monitor, and that segues quite nicely now to our next speaker, Charlotte, who will talk about these slap suits and the risks that investigative journalists face when working with whistleblowers. So, Charlotte, thank you very much. The floor is yours.
Thank you very much, Ida. Thank you very much for your invitation. So I would like to speak about the mission of the FPL, which is the Fund for a Free Press. And after I will explain you how the new fund we set up a few months ago is directly linked with the whistleblowers. So the Fund for a Free Press was created by Mediapart, which is an independent media outlet in France. It was created in 2019. So I've been working for the fund since 2020. And this fund was created with 2 goals. The first one was to make the capital of Mediapart fully independent. So it was implemented at the end of 2019. And after the second mission is a mission of general interest. So this is the first fund in France which support the independent press. This mission of general interest is to protect and defend the press pluralism, the freedom of information, and the independence of journalism. This is the first time in France that the French administration recognizes as a mission of general interest the mission of the fund. So with that, we support the independent press by providing financial support. The financials, so yes, thank you very much, Ida. You can see all the independent media outlets we supported since 2021. So we provide some grants. So we give money to independent media which make applications to the fund. So we have project with innovation of editorial innovation or Some media present some project of investigations. But also we can lend some to independent media, which are loans without interest rate and ask any guarantee. So we lend money to independent media. So it's not big amounts. It depends of what we are talking about, because for independent press, this kind of amounts are very important for this media. For example, we supported a project last year with like 60,000 euros, which is not so bad. And by giving this money, we try to increase and to strengthen the business model of the independent media in France. We are allowed to support independent media based in France, but also at the European and also media based in the European Union. So for the last 6 years, we supported more than 50 independent media outlets with the total amount of 1,370,000 euros. And this money come from directly for donations coming from individuals, and we receive also some support from French foundations, but also European foundations. So we are a small team. We are only 2 permanent salaries, so we are only 2 persons leading the fund, and all the other members of the fund are volunteers. So it's I can say, I mean, that the fund is one of the main actors supporting in France the independent media outlets. And if I want to be more precise with your the subject of your webinar, that we realized and we were informed by independent media outlets for the last few years, like the last 3 years, I think, that journalists are more and more attacked by economic actors, political persons, or even companies in the frame of some investigations they made and they make and they published. So they are more and more attacked in a legal way. So we last year during our crowdfunding campaign, our annual crowdfunding campaign, we created a partnership with an NGO, international NGO named Media Defense. Maybe you know this NGO. This NGO, the task of this NGO is to protect journalism all around the world, in several dozens countries all around the world. And we decided to work together and to create the first legal aid fund in France in order to protect and to defend the journalists, the investigative journalists in France and also in Europe, but most part of the time in France, when they are pursued or when they have when some people bring a case before courts in France, because this kind of cases, the legal cases, are contributes to weak the independent medias. It contributes to the self-censorship, because the aim of these legal actions are used to intimidate, to financially exhaust, or to make the media to close the door, to close the door of the media. And so this fund, we called it Riposte, reports mean in France, with the idea to how to say, to put the fear on the other person. I mean, we want to make understand to the actors which bring these cases to the courts against the independent media, to make them understand that you have to stop it. You have to stop this censorship. You have to stop too weak and to how I can say how to undermine the medias. I mean, we with this fund. So this fund, when you make an application to Media Defense or to the Fund for a Free Press, you ask the fund to take in charge of the, for example, the fees of the lawyer, and also for the transportation, for when you need to book an hotel in order to go to the court for your audience. So we take in charge totally or partially all the cost in the frame of the legal actions. And we also want that the lawyers ask damages, to claim damages for this economic actors, or even for this political person. So yes, thank you for the slide. So as I told you, this fund, the Riposte Fund, was created in few months ago, like in October 2025. And the thing, we were very surprised because during our crowdfunding campaign, it was one of the second goal of our crowdfunding campaign. We wanted to get 100,000 euro for this fund in order to be able to defend the independent media in the frame of the legal actions. And we were a bit surprised because we were not very convinced that we could collect this amount, but we did it, and we did it only in 2 weeks. So we were very surprised. So now this fund has 100,000 euros for the next 2 years. But since October 2005, we already received 5 applications from independent media outlets in France. And the thing is that we already spent 26,000 euros. So we are convinced that the initial amount we collected won't be sufficient. I mean, in order to defend the investigative journalist and the independent media in France. But we would like to get more and more money to be stronger, and to say to the people who attack this kind of independent media that you have to stop. So we are positive, we are optimistic, but it's a hard work to succeed. Anyway, the thing I wanted to say is this fund, Riposte Fund, is dedicated to the investigative journalists in France, but also the independent media. But it's directly linked to the whistleblowers, because if you undermine the media which investigate, which reveal public information of public interest, it means that also undermine the whistleblowers. So to protect this journalist, we would like indirectly protect also the whistleblowers. We cannot give money to the whistleblowers because the French administration doesn't allow us to give them the money, but indirectly, if we protect and if we defend the journalists, we protect as well, I mean, the whistleblowers. Because if you attack an independent media, it means that it creates a deterrent effect on the whistleblowing, but also it creates also a negative impact, I mean, in the public interest and information, and also on the audience and on the public debate. So for us, it's really important to make this fund still exist, and to get some support in order to still protect all its missions. And also, but I will let Moira to explain a bit more our collective actions, because we work together in our awareness actions, that we also launched a coalition against slaps a few days ago by publishing a tribune asking the government to transpose the European directive on the slaps as well in the French legislations. So we work together with independent media outlet, because this tribune was affirmed. We got some more than 150 50 independent media which joined this tribune and these coalitions, but also we have NGOs like MLA, Maison des Lanceurs d'Alerte, or Sherpa, or Reporter Without Borders, or Transparency International, or Greenpeace. So we can see that if we join our forces, the civil society, the independent media outlets, and also other like trade unions, we can be strengthened in order to make this protection against this protection for the whistleblowers and for the independent media outlet and for the press in general more resilient. I mean, for in order to I don't know I don't find the word, but you know, if we work together, we will get a stronger protection for the press, but also the whistleblowers. So thank you very much for listening, and I will put you on the chat the link to consult our last impact report. Thank you very much.
Thank you so much, Charlotte, and congratulations on this success that you've had very early on with the funds. It's really interesting to hear. I have a couple of questions I was furiously writing down. I'll save them to the end, but in the interest of time, I'm going to pass just straight over to Moira. Thank you.
Hello, can you hear me well? Yes?
Yes.
Yes, perfect. So yeah, my name is Moira. I work at the Maison de Lanceurs d'Alerte, which translates as Whistleblowers House. And about a year ago, we have published a guide for journalists working with whistleblowers, which I will be presenting to you today. And it's also a good way to link to Charlotte's presentation, which is how journalists can protect themselves, but how journalists can also protect better their sources. But before, I would like to introduce my organization. The Maison de Lanceurs d'Alerte. So it was created on October 22, 2018 by, sorry for the noise, by a coalition of 17 organizations, including civil society organizations and labor unions from different sectors. And its mission is simple but essential, ensuring that whistleblowers are not left alone. And since its creation, the MLA has contributed also to shaping the legal framework, particularly through its involvement in the drafting of the Wasserman Act, which was adopted in 2022. This law has improved the protection of whistleblowers in France. It is not perfect, obviously, but it has certain improvement measures compared to the first law. Our work is also to advocate for the right to blow the whistle and to develop a culture of whistleblowing in France, because our work is part of a broader vision that of a pluralistic democracy where whistleblowing serves as a form of citizen oversight. So basically, the more the law is known to public, we believe that the better its implementation will be. But beyond legal advocacy, the work of the Maison de Lanceurs d'Alerte is deeply practical. We have received over 1,500 reports since our creation, and we have supported more than 450 whistleblowers in France. Next slide. So how does this support actually work? Whistleblowers need a comprehensive protection, and at the Maison de Lanceurs d'Alerte, we provide it. First, there is legal support, and for that, we have a whistleblowing secure platform. The priority is to assess whether a person meets the legal criteria required to qualify as a whistleblower. If so, the organization can issue a support note recognizing this status. But legal protection is only one kind of the protections we provide. Whistleblower also comes with heavy psychological burden, and which translates with isolation, fear of retaliation, and long legal battles, the SLAPS measures. And that is why we also provide psychological support. And we also assist with media exposure of the alert, which is strictly regulated by law. Finally, in some cases, financial support can also be provided in cases of job loss or economic hardship. Yeah, we can change the slide. Yeah. So why we have published a guide for journalists. So whistleblowers are a type of journalistic source that fundamentally challenge the way investigative journalists address their work. While journalists are very familiar with source protection laws, we at the MLA, we have noticed that they are often unaware of what a whistleblower really is. This is likely because the laws on whistleblowing are relatively new, and because also they are very technical. And the general legal framework for the protection of sources has been supplemented, reinforced by a specific protection regime for a particular source, the whistleblower. However, not anyone can benefit from this status. So what they have in common, sources and whistleblowers? Whistleblowers and sources, any source, take significant risk when going public, legal, professional, and personal risks. They may lose their job, they may face lawsuits or be subjected to various forms of pressure. But unlike traditional sources, whistleblowers must meet a strict legal definition to qualify for protection. In France, for instance, because I know better the legal framework in France, A whistleblower must meet a set of criteria defined by the law, and above all, follow a structured reporting procedure. Only those who comply with these conditions can hope to benefit from the legal protections associated with whistleblower status. And finally, media exposure is also strictly regulated by the law. And without going into too much detail, because it is very technical, it can only take place 6.5 months after the matter has been referred to a competent authority. So this means that going public too early can result in the loss of the whistleblower's protection. And that loss is sometimes irreversible. In other words, a person who might have been protected, had they followed the proper procedure, can lose that protection entirely simply because the alert was publicized too soon. To address this, so the Maison de Lanceurs d'Alerte has published this practical guide publicizing an alert intended for journalists, but also for whistleblowers in 3 countries, France, Belgium, and Switzerland. But we also have a European framework analysis. Next slide. The guide uses a color system, coding system. So it provides a detailed overview of legal frameworks, protections under limitations, but more importantly, it offers concrete advice on how to navigate every stage of a journalist investigation before, during, and after the publication, and goes beyond legal considerations alone. It also includes practical advice on aspects that are often overlooked but equally crucial, like mental health and the protection of the journalist, of course. And its objective is clear: to enable journalists to work with whistleblowers without compromising their safety or legal protection, and to also take into account your own protection. So next slide, please. So the guide emphasizes, it has very many objectives. It helps to identify what distinguishes a whistleblower from a traditional source. It also highlights tipping points, critical moments where a mistake, aka not following the procedure, could expose the source or undermine their legal protection. And it stresses the importance of making source protection a central editorial priority, not an afterthought. So yeah, I think that's basically it. Please, the next slide. Yeah, and among its most practical contributions of the guide, we have the 10 golden rules, which I invite you to discover in detail by downloading our guide. But some of you might be actually wondering about the implementation of the decree, because that is a question that we often receive, is that, to be honest, there is a huge gap between the law and its effective implementation. The truth is that in France, at least in France, but I don't know from where you come from, but I think you can also identify with this issue. The truth is that whistleblowers in France are not protected, and that the Wasserman law is not being implemented. However, we believe that it is important for journalists to know the law, to at least allow the source, so the potential whistleblower, to benefit from this legal status, even if it's difficult to obtain. Because we actually have good examples of whistleblowers and journalists working together while taking into account this legal framework. So, for example, we have a case called Hervé versus Veolia. So Veolia is a big company in France that basically manages the water quality, but it is private. It is private. So in a region called the Gap, the local authorities have give this market, which is paid by the public funds, to the Veolia to actually clean the water of a river called La Durance. And this whistleblower worked in that company and realized that the measures of sanity, of quality of the water were not being respected by the enterprise. So they have contacted us. He has contacted us very early on his procedure, and also we have contacted two journalists, one from Mediapart, which Charlotte has presented, and the other from a local radio called Ham 05. And we have followed every step of the publicizing of this alert. We have been there before, during, and after the publication. So the journalists have really well respected the directive and the procedure described in the French law. And this is actually a good case because this case is actually advancing well legally. The whistleblower has been recognized as a whistleblower by a jurisdiction, which is actually very complicated. And we believe that this is also because the publicizing strategy was very, very effective. I think this guide should be used as a tool, as a risk management tool. What I mean is that on the other side, people or organizations, big corporations will attack you no matter what, even if you respect every single step of the procedure. But the risk is reduced as its maximum if we follow this procedure. So that's why we have published this guide, and we have detailed it in different steps. Thank you very much.
Thank you so much, Moira, and it's a fantastic resource. I can see that Ed has posted a link to the report in the chat, so please do take a look, and maybe there will be some questions for you in the Q&A at the end. I think I'll move quite quickly on just to mention some of the other resources that those on the seminar might be interested in. Obviously, you've mentioned this guide, which is also available in French and English. Is that right, Moira?
Yes, I will post the English link if it's not.
Fantastic, thank you. We've mentioned the EU Whistleblowing Monitor today. There is also another guide I thought I'd mention. It's a couple of years old now, posted by the European Federation of Journalists early on after the adoption of the EU Whistleblowing Directive. And there is a sort of one-page guide also attached to that, which sets out some of the relevant provisions that complements what Anna presented earlier on today. Just very briefly also mention the WIN Resources Library. I'll jump forward one slide. You can actually search on there under the category Journalism and Source Protection, and you should find some of the other standards and best practice tools there are for investigative journalists, particularly with regard to whistleblower and source protection. And just a quick mention as well, Moira, you mentioned the secure reporting platform. One of the members of WIN who also provides some of these secure reporting anonymous two-way communication tools that many media houses have implemented. You can see here Global Leaks. I'll also post a link to them in the chat shortly. I think that run out of time somewhat. Just a final summary of the Whistleblowing International Network. There are a number of free press and media organisations that are members of this network, and you know, a sort of call to arms if you're interested in being more active in the sort of whistleblower protection movement, as it were. Please do reach out to them. I'm also posting a link in the chat to access their global update, so a sort of regular updates on whistleblowing law and practice around the world, not just in Europe. And without any further ado, I'm sorry to be boring, but there is a donor required survey. Again, link in the chat, or there's a QR code on the screen. I'll also copy and paste the information there. It just takes a few moments. And it'll ask you some questions about your experience of the seminar today, but then also they're collecting information, I think, on perceptions of EU law and rights generally. So just to be aware, there are a couple more questions at the end about that. But if you could please spare a few moments. This webinar isn't over. We will stay online until 15:15 in case there are any questions for our speakers. But if you don't join us, thank you very much indeed. And thank you for all 4 of our speakers for joining us and for their very interesting presentations. And we will now stop the recording and hope that you can join us for some camera on Q&A.